This episode was co-produced by Startup Days, the Swiss networking and business event for startups, investors, enablers, and corporates. Check out startupdays.ch to learn more about this year's edition taking place in Bern on May 30th. Again, that's startupdays.ch.
The worst case normally is success. Sounds strange, but as long as you are paying, everybody is willing to collaborate. But once you are gaining money, then you start sometimes quarreling who gets what. And if you haven't done your contracts in the past, nobody will be willing to sign you any contracts once you are in trouble.
Welcome to the Swisspreneur Show, a podcast about startup stories and learnings from experienced entrepreneurs. If you enjoy listening to our show, make sure to follow the podcast and leave a rating. And now, here's your host, Sylvan.
Matthias, Adrian, a very well welcome to the Swisspreneur Show. It's a pleasure to have both of you as guests today.
Pleasure is on my side.
Thank you for having me.
Adrian, you're the founder and owner of RNX, short for Riedo Networks, a provider and distributor of energy monitoring and controlling solutions, which began back in 2005. So I was wondering, what motivated you to start your own business back then?
After graduating from ETH, I always wanted to found my company, but obviously when you finish your studies, you first have to work in a few companies to learn the business. Roughly after 5-6 years, I said to myself, let's do it. But honestly, I did not have a product in mind. It came 1 or 2 years later when a friend of mine approached me with an idea for data centers. And since then, roughly 20 years, we are in that domain and growing slowly but steadily.
Amazing. And Matthias, you on the other hand, you are a senior IP trainer at the Institute for Intellectual Property in Bern. What continues to fascinate you about the topic of IP?
Well, first of all, you get to know a lot of interesting people with their terrific products. And I love to help them securing their success in the future by providing information about intellectual property, about information about patents, trademarks, designs, copyright, so that they will have their success in future secured. IP offers also a link between economical progress and protection of the corresponding competitive advantage, which for Switzerland is extremely important. So for me, it's also like securing success of Switzerland as well.
I love that. That's a fantastic motivation to have. And today we really want to talk about the topic of intellectual property rights with a Swiss startup perspective and focus. So Matthias, just right over to you. Why is it crucial for startups to really prioritize and protect their IP rights right from the outset?
Well, I would say the very most important thing is you have to pay attention to the topic. It's not so important whether you really use the IP system, whether you really protect yourself or not, but you have to look into the topic from the very beginning. This means you have to integrate also an IP strategy into your R&D and business strategy as well, because as an inventor, you have to be conscious about the fact that you can ruin from the very beginning the chances of protection, for example, by just talking in public about your invention. That in the past happened before, and that's simply so bad. And you want to help the people. So for me, the most important message is make a conscious decision about the use of intellectual property rights, about the use of patents, trademarks, designs, or copyright, and check about the alternatives. The IPI is offering a checklist for an IP strategy on our website, so this might also help startups to get into contact with the different questions. So just check our website.
Amazing. So this decision is very important from the get-go. And I wonder, Adrian, how soon into the RNX journey did you guys start taking the initial steps regarding your IP protection?
When we developed our first product back in, company was founded in 2005, but the first real product, physical hardware, electronics product, was designed in 2007, 8, 9, in that period. And when we actually had a product idea and knew how to do it and what to do it, we looked into, first of all, trademark registration pretty soon. And that's quite an easy thing to do. Once you have a name, company name, product name, it's more or less a no-brainer to do it because it's not very expensive and straightforward. But as a matter of fact, when it comes to the patent side, we had the idea to patent it, but several things were telling us not to do it, and that was money. We thought it's too easy to get around the patent, and also by that time we had colleagues who did an MBA and did our product idea and company startup as a project in their MBA finals. And their expert also told us that, yeah, you can do it, but it will cost you a lot and it's very easy to get around that patent. Funny enough, whenever later in the company we grew and we talked to bigger companies and potential customers and partners, it was always a question, do you have a patent? And most of the time I said, we didn't do it, but we could have done it. And also looking back now, it would have helped us in the process, I guess. But it really boils down to the fact, is there enough flesh to the bone to do a patent and to pursue it? Later, a few years back, so when we did several iterations of our product, roughly 5-6 years ago, we had enough flesh to the bone, but this time we also had the money and the experts saying, green light, do it. And so we did it, and maybe it's not the moment to talk about it right now, but so we looked into it very soon, but as many small startups in the beginnings, you're afraid of that. So I really want to underline what Matthias just said. Look for good partners, good experts, do that checklist and make up your mind. Do I want to follow that route or not? Because as soon as you talk about it publicly, you cannot patent it anymore.
I love that. And I feel that many founders are probably in the very same shoes as you once were. They ask themselves this question, what should I do and what options do I have? So, Matthias, what types of IP are the most relevant for startups? And can you also talk a bit more about how they differ in terms of protection and application?
Well, you can't say this or that IP right is the most important one. It all depends on the field of product, your resources, and your strategy. For me, the most important question is, where is your competitive advantage? Because that's where you want to invest. Because in the end, when we are talking about intellectual property rights, we are also talking about costs, because you have to apply for these intellectual property rights. So for me, it only worth is to invest money where you have a competitive advantage. If it is a technical solution, then patents are critical. If we are talking about services, then trademarks are very important. If we are talking about software or apps, then copyright and trademarks are fundamental. And on the other hand, if we are talking about luxury products, design rights might be relevant. So it all depends on the product and then about your decision whether you want to use IP rights or alternatives. For me, this leads to a very important task that every startup should do, and that is analyze your product and the competitive advantage, and then check which intellectual property right suits this, suits it best to protect this competitive advantage. Again, the IPI is offering also different information services and also trainings. There you can find a lot of information on our website. So please just check.
That makes a ton of sense. And you already shared your journey a bit, Adrian. You first went for the trademark, then later down the road, you filed the patent as well. I just wonder, what were some of the challenges that Arnix faced during the early stages of the development regarding its IP?
Yeah, so we did several IP protections, a couple of trademarks, product names, company logos, and then also the patent. Now, when it comes to trademarks, the challenges we faced were when you apply for it, that suddenly a company with a similar name writes a letter from an attorney to you that you should not use that name, even though the name is spelled differently. So our challenge was, hey, that's an attorney writes us a letter and you're like having fears. So don't get into that rabbit hole. Just ask for advice. Even if it's just a friend who just studied legal at university could tell you, hey, calm down, it's not as bad. You find solutions. So when it comes to trademark, you can resolve them quite easily, and don't give up. And they even dared to tell us once we settled it that we should that we should pay their internal cost, which I said, come on, no. So trademarks are actually easy to apply, but the challenge is you will get here and there letters from large companies. In our case, it was a Japanese company, or when it was in the US, you get a lot of hurdles saying, yeah, that name is too close, or you have to redefine your market specifics, because every trademark you need to obviously tell for which market, what product categories you want to file it, and so on. When it comes to the patent, the most challenging part was in the beginning to redefine exactly your claims. When you have a genius whiz-bang idea and you want to protect it, of course, first of all, you never talk about it. You keep it secretly. You're not publishing it. But then when you go to a patent attorney and you're going to start writing your IP that you want to protect, so in this case, a patent, the challenges were really to refine exactly what your claims are, what you're about to protect. And we always put the umbrella on how actually could you get around it. And that helped in that process.
I want to add one thing that what Adrian just said when it comes to trademark protection, because a lot of people get additional fees or from private registers.
Yeah.
They look quite official, but just be aware, these are private registers. So it's not a fraud, but if you like to pay private people for their private register, pay them. But otherwise, the only register you really have to be in is the National Trademark Register, and that's it.
Yeah, that applies for every country. So we got a ton of these letters and they all went to the trash bin.
I love that. Yes. That's probably the only strategy you have to enforce in that regard when you get these letters. Matthias, you mentioned before the importance of having this comprehensive IP strategy to really think, what can I protect? What is sort of my moat, so to speak? And in what role does IP also play a part when you think about attracting investors and partners to then support a startup's growth? So once you are above this initial startup phase, now we really want to grow. How important are patents and IP in that regard?
Well, I can remember a survey when venture capitalists said that intellectual property is one of the key factors when it comes to decide whether they want to invest into a startup or not. So if you can demonstrate as a startup that you have invested time and resources, for example, into the research, that you are not reinventing the wheel, that you made, for example, a patent research, and that you are conscious what might be protected or not. And on the other hand, if you can show that you check that you are not infringing third parties' rights, this simply shows your competence and makes you more attractive for future investments. On the other hand, you can also use intellectual property rights, for example, as a source of information. This is something that a lot of people forget. We are talking about registers with, when it comes to patents, about 130 million documents, free to use, information that lies in the register, and everybody can check, so that you are not reinventing the wheel. So please use this information from the very beginning. On the other hand, if you are owning intellectual property rights, you can use it also to have access to third parties' knowledge, for example, via cross-licensing, or you can boost your reputation. For example, a patent proves your innovative skills. And of course, intellectual property rights can be used as a source of income by selling or providing licenses for your rights, of course.
Thank you for sharing all these different applications and upsides of the IP protection. On the other hand, I can also imagine that there are stories that you have come across, Matthias, where startups faced legal challenges related to IP. Do you have any stories or any examples to share there?
Well, I don't want to throw anybody under the bus. And also, the IPI offers only the opposition procedure and the cancellation procedure on grounds of non-use of trademarks. All these decisions are published and can be checked on our website. But you only have to read our newspapers. Almost on a daily basis, you can find examples about patents, trademarks, designs, or copyright infringements. So we can, for sure, we can say the topic is absolutely relevant.
And in that regard, I also took a note to remind me of the freedom to operate searches. Can you tell us a bit more what they are and why they are very important for startups?
Well, I would say a freedom to operate research is absolutely vital before you go to the market, because you want to make sure that you can implement your business case and you won't get into trouble with third parties. Because the freedom to operate research includes all the different aspects of your product, even, for example, of your communication strategy. You want to make sure that you're not infringing third parties' trademarks or third parties' copyrights. So in today's markets, one product includes various rights for different parts of this product. And we have to check that we are not infringing anybody's rights, because especially as a startup, once you want to go to the market, you want to sell, you want to have income, and you don't want to wait another year because there are legal troubles according to all these intellectual property rights. So as a startup, even once you have decided at the beginning that you want to use an alternative to patents, trademarks, designs, whatever. You have to make sure that, or be aware that your competitors are confronted with the very same questions. And they might have come up, according to their resources, to their strategy, to another decision. They might have applied for monopoly rights, for patents, trademarks, and design rights. So even if you have considered that for you intellectual property rights are not important, you can't simply skip this topic. You have to respect third parties' rights, and you have to make sure that you are not infringing these third parties' rights.
It sounds that if you are a startup and you just enter the market by not doing your homework in that regard to really, perform a freedom to operate search, this could eventually even kill your startup to a certain degree.
I know some examples that where companies have changed their product after they have done patent research at the IPI or changed a bit the strategy. So this happened before, yes. And I mean, that's a very costly adventure. Once you want to go to the market, then you have to change. That is why I said before, use this information from the very beginning, so that you are not investing time and money into something that in the end, a big company is simply waiting with their lawyers telling you you can't go to the market.
Absolutely. And Adrian, for you as an entrepreneur, I imagine that you also have to strive for a certain balance. On one hand, you want to move fast, you want to perform open innovation, collaboration, but at the same time, you sometimes also have to really take care of protecting your IP. So how did you, or still do, navigate this balance between these different areas at RNX?
So first of all, let me quickly underline what just Matthias said. When you start a company, when you're in the startup phase, you're like out in the green field and you don't know what you actually do. And if you just innovate, throw it to the market, you can be lucky. You're not infringing anything. Everything is okay, and you have a great product. You sell, you do. But it can also turn bad if you think I have a whiz bang idea and actually the core element of your innovation is patented. So in our case, I really want to underline what Matthias said. We are fortunate and lucky enough to have experts looking at our innovation if it is patentable. We came to the conclusion we don't have the money, we don't have the funds, we don't have the feeling that there is not enough flesh to the bone. But on the other side, it also led us to the know-how of what is actually out there in the domain, what is patented, and what we actually do is not infringing already an available solution. So actually, you have to stop at a certain point to look for it, because you otherwise you waste all your time in just looking for other patents, but do a basic search. So I just want to underline what Matthias said. Now, when it comes later, when you have a product, you know the market, you know what your counterparts are doing, this game becomes much easier. So for us also to do the patent a few later, so once you're already in the market, was extremely easy to do compared when you're a startup. Now in our company, when we innovate every day, and whenever we have meetings and we think, hey, there is enough flesh to the bone, that this thing could actually be something that we protect with IP, naming a patent. We have a process in place where we then treat that project or this idea differently, meaning protected. There are clear rules, what you can say and what you cannot say. And especially when it comes to disclosing information with partners, obviously nothing goes out without NDAs and clear documents. And there are templates, there are experts that can help you with that. But the basic rule is very, very easy. If you think you have an idea that might end up in some IP protection, be careful and keep it to yourself, because once it's leaked, it's pointless. We were even in the situation where we had to defend our sites, where we could prove, for instance, that other ideas were public domain before even the patent was there. So as soon as it is public in any form, can be on a napkin, it will be hard to get a patent for it. So make those processes in your company, make your people aware, and whenever you need to share it, have it backed up with NDAs and that sort of legal documents.
Fantastic. Thank you for sharing these very practical examples. Matthias, back to you. Switzerland is quite a small market, right? So after we got the initial phase off the ground, we often want to expand to other markets around the globe. So what does that mean from an IP perspective? How can we also make sure that we are protected on a global level as a startup, as a company with our IP needs?
Well, apart from copyright, you have to be conscious that for patents, trademarks, and designs, you have to apply. And you have to apply in each and every country you would like to have your monopoly right. This also means you have to pay for it. And now we are a startup, so we don't have money to apply in each and every country. We have to accept this fact. Now, for me, because we don't have the money for a worldwide protection, for me, there are two leading questions. Where are your main markets? Or where are your main competitors? Sometimes also a third question is important. Where can you enforce your rights? I mean, this will limit the scope of protection also for a startup so that it will get affordable. But again, now the question is, in which countries do we really need this protection? I'm coming back to what I said before. Each and every company has to analyze where is our competitive advantage and which protection suits this best. So this will limit your efforts again. Which intellectual property rights do you really need? And by doing these analyses, you will save your money and trouble in the future. When it comes to costs, again, our website offers an overview and sometimes also a fee calculator on a national and international level, so you can check. But also what is very important to consider is the costs for all these fees to apply for intellectual property rights. And that's not the big bulk. You also have to consider when you want to have legal advice, which we strongly recommend, you have to pay these attorneys as well. And this might be more costly than all the fees.
Understood. I think that's a very important thing to consider. And I wonder from the practical side with you, Adrian, what resources did you consult to really navigate the intellectual property landscape nationally, but also internationally? Did you require any special support along the way?
Just before answering that question, what Matthias just said, that you have to apply it for every country, is true. Just as a side note, since a few months in Europe, you have 17 countries combined under one roof, which makes it much more affordable. Really, from a practical side, your expert, your whatever patent attorney you choose can help you with that. But in our case, for instance, it made it much cheaper than a year ago when every country was individual. Once you think you want to, let's say, do a patent and protect it, first thing is obviously to go to a patent attorney. And many people, especially engineers or startups, don't know that these are not actually attorneys in a traditional sense. A patent attorney is a technical people, mostly an engineer who actually analyzes your idea, consults you, helps you write the patent application, the patent itself, the claims, and they look at it from, of course, patent legal perspective. So this is what we did. We have a very good patent attorney from Bern, who is sticks with us since many years already. It's always the same person. He understands what we want. So what you should do is look for a good partner that can help you go through it. When it comes to the trademark itself, it's a bit easier. Basically, the IGE, for instance, Switzerland can help you register, and I think they even have support when you go abroad. But when it comes to patents, we went to a patent attorney, and also it's never bad to make an NDA with friends who actually maybe also have done a startup, which can give you fresh minds, perspective, or ideas. But always there, even if it's your mom, your father, your best friend, whenever you talk about your invention that you eventually want to patent, have a legal NDA prepared, sign it, and then you can talk about it. So this is what we did. We did not have to consult legals while doing the application. Later, when it came to the application in the US, it boiled down to the fact that they were not happy with some claims or some wordings, and there we needed extra legal advice, which is an extra round, an extra few thousand. But don't be shy when you start. The costs are in the orders of a few 10K, which can be managed. The hefty price usually comes at the end of the 20 years. And the yearly costs to maintain the patent in each country is not linear. So the last few years become the most expensive ones. You can always say, I withdraw from the patent after 16 years and don't pay the last 4 years. But getting off the ground and going through the process helps you in redefining what you actually do, writing it down, be sure about your claims. And when you talk to other, especially larger corporations, it's a nice asset to have.
No. And I love these very specific numbers that you were able to share. I think that's very helpful for entrepreneurs out there to give them a ballpark figure about what we are talking here. If we stay on the global level, Matthias, I also wonder, we have seen a rise of open source software and in general collaborative development. In what way does that impact or even challenge the intellectual property considerations for a tech startup? Because I imagine some stuff might not that easy to protect anymore.
Well, I would say that especially when it comes to open source or collaborative development, licenses and contracts are extremely important. When we are talking about open source software, I know it's not very exciting, but you have to read the general terms and conditions as well as the license policies, because otherwise you even would like to ask for a protection, but in the license of this open source, it mentioned that you have to share on the same conditions as you have taken over the information. You have to share this with all the others, and you won't have any possibility for an intellectual property right. Also, especially when it comes to collaborative developments, regulate questions about IP, like who owns future intellectual property rights, who is responsible for freedom to operate, and all other IP aspects always by contract. And please, in written, not these oral contracts. And I really want to stress out what Adrian said before. Contracts are so important. How many times have I heard the story? I and my best friend started at the university. We built our company and everything was all right. We knew each other for 15 years. But then the worst case came, and worst case normally is success. Sounds strange, but I mean, as long as you are paying, everybody is willing to collaborate. But once you are gaining money, then you start sometimes quarreling who gets what. And if you haven't done your contracts in the past, nobody will be willing to sign you any contracts once you are in trouble. So you have to sign these contracts from the very beginning. Contracts are building trust, and please start from the beginning. That's absolutely important. Unfortunately, we as the IPI, we can't offer any templates, but we strongly recommend external consultants. As Adrian mentioned it, there are specific lawyers, patent attorneys who know exactly what has to be written in these contracts. So again, that we will have success in the future. That's the most important thing.
Thank you. And Adrian, talking about money, usually money also flows in when you are thinking about an exit of a company. So I was wondering, from an entrepreneurial perspective, what role does IP play in your exit strategy for RNX, if you even have any exit strategy?
So first of all, we're a family business, and obviously, no, we don't have that strategy. It's our baby. We have fun with it, but you never know what's going to be in 10 years. But no, there is no exit strategy. And I think also that in modern times, teach the kids to start a company and think about an exit strategy. Yeah, why not? But I think it should not be the main topic. I never started the company with an exit strategy in mind. Even so, if you want to go that route, obviously IP plays a very important strategic role. Honestly, most of the patents you can get around are not as strong as they look at first glance. But when it comes to collaboration with larger corporations or selling the company or have an exit strategy, whatever, it becomes a very valuable asset. The other thing that in my opinion, where IP rights shine, especially patents, is also as a defense mechanism. Because especially for a startup that has not much money, or even like ours company, which is not so big, we probably, when we would see an infringement of our patent in the field, would not have the funds to go after every single infringement. But if, for instance, yourself are in a domain where you might be close to another patent, this asset can help as a weapon to defend yourself. I mean, you're not trading IP rights, but just the fact that you have done your due diligence, that you have done that huge homework to go through the process and have a patent, puts you on a completely different level of perception in the market. So, in my opinion, if you think you can go for a trademark registration or a patent, and you can pay it over the years, then do it.
So it's a very valuable thing to have and to obtain. And there's another thing, even if you don't want to sell your company, it's licensing agreements to really monetize your IP that you built up and protected over the years.
Exactly. Or for instance, you have maybe a patent, you have a product, you're selling it, but then suddenly a large corporation comes around the corner and maybe doesn't want to acquire you, but would like to collaborate with you or take your core technology. And then you say in your first meeting, hey, by the way, what you would like from us is actually covered in our patent. It puts you just much higher in perception towards a larger corporation that if you would say, oh, yeah, let's do a deal, but it's not protected anyway.
Absolutely. And I wonder, Matthias, how can you actually leverage this IP that you built up as a startup to really also sort of generate an additional revenue stream and income for your company?
Well, I can't provide any numbers because we are dealing just with the applications. But together with specialists in the field of intellectual property, we have created a checklist for IP licenses. So again, people can check on our website and have a closer look on the different topics you have to think about when it comes to license or even to sell your IP.
Got it. And I also like to talk about the future, look a bit into the future. Matthias, what trends should entrepreneurs be mindful of in the coming years in regards to intellectual property rights?
I think that the topic of intellectual property will keep growing because in today's markets, it is increasingly difficult to distinguish your offer to those of your competitor. So again, what you can sell is your competitive advantage, and you have to consider to protect this competitive advantage, and that is the field of intellectual property. Especially for us in Switzerland, intellectual property is very important because we don't have any natural resources. We don't have oil, gas, rare earth elements. Our natural resource lies in our brains. And we don't want to get our ideas and innovation be stolen by third parties. And that is what we need intellectual property rights for. So I think for future startups, the tasks in the future are the same. Make a conscious decision about intellectual property rights and integrate these questions from the very beginning into your innovation process. And deal with these questions in an active way. Don't let the market decide for you.
That's a very clear statement. I love that. And Adrian, we hear the natural resources of Switzerland are brains like yours and your teams. So I'm curious to learn more about the future. What can we expect from RNX in the near future? And this, of course, doesn't have to be related to IP.
Yeah, obviously, I won't talk about future IP protection that we have in mind. But obviously, there are always ideas. We have constant so many ideas. But in one word, what you can expect from us is expansion. We are now, after a few years, in a phase where we grow. So we deliver down to Israel. We are now also going west. So we have distribution startup established since 2 years in the States. And this is what you can expect. International growth. In Switzerland, we did the homework. It's almost impossible to grow more. We have our market share. This is what you can expect. And this is also where IP protection, especially also patents, are so much important. And it boils down to what Matthias said. You need to be active, think about it before it's too late. And maybe sometimes you don't need that kind of protection. But if you don't look into it and expand, and then after a few years realize, oh, we should have registered the trademark or done this and that, it's usually too late or will cost you more. So advice, expert knowledge is accessible and affordable in Switzerland. And this is my message. Just ask for it.
I think we if we want to look a bit into the crystal ball, we have to talk about artificial intelligence as well, because it will also be an aspect for intellectual property. We don't know yet where the journey will end, because we don't have any decisions by any court so far. But I think we have to deal with this question in the future, whether we will integrate it in existing laws or whether we will find a different way to deal with the output of artificial intelligence. We don't know yet, but I'm pretty sure the journey will be interesting in the future as well.
It will also keep you busy, I'm sure, Matthias. You'll have more work coming your way in that regard. I would like to thank you both for your time today and for this masterclass on intellectual property rights for startups. Thank you so much for joining us here today. And I wish you all the best and lots of success for the future. Thank you, Adrian and Matthias.
Thanks for having me.
All the best to all the future startups. Keep up the good work.
We hope you enjoyed today's episode. If you did, you can support us by rating our show on Apple Podcasts. This way, we can reach an ever-growing number of aspiring entrepreneurs.